I've been served with a summons and I'm not sure what to do next. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. And today we're going to take a look at that situation where you've just been served with legal papers and you're probably not too happy about it and you aren't sure what should you be doing next. So to take a quick step back, if somebody is going to file a lawsuit against you or they're going to sue you for something, the first thing they have to do is give you notice of that lawsuit. And the way they give you notice is by serving you with documents. Now, you've probably seen this in movies and TV shows where there's a big dramatic effect of somebody hiding in the bushes and they jump out and hand you papers. And that does occasionally happen, but normally it's a lot more mundane. Maybe you come home one day and there's somebody who walks up to your doorstep and rings the bell, says, "Are you John Smith?" And you say, "Yes, I am." And they hand you papers and they say you've been served. Each state has their own rules and requirements for what service looks like. So in some states, when in that situation, if you say, "I'm John Smith, but I'm not going to take the papers," all the process server has to do is drop the papers at your feet, and it's considered to be good service. And many people will want to try to challenge the service, and that's called a traverse hearing, and that will go into whether or not you were properly served with the documents. But assuming you have the documents by whatever method, the first thing you should do is take a deep breath. It's going to be a dramatic scene in your mind. You're going to be upset. There's probably a large stack of papers. Sometimes there's not. Maybe it's just 1 or 2 pages. Other times it's a couple hundred pages. Whatever it is, it's going to upset you. You're not going to be happy. I've never met a client who said, "I'm glad I was served." So first thing to do is take a deep breath. Whoever served you with the papers at the time they've served you is having the best possible day they can have in that lawsuit, because you didn't know it was coming. You've been shocked with those papers. You're in a bad place. You're not sure what to do next. You're nervous. You're concerned. Meanwhile, the other party is happy. They knew it was coming. They worked with an attorney or they filled out the paperwork. They had it served on you. And if you talk to them after you've been served, they're probably going to be gloating. I had clients last week who the other party had served them with some papers, and it was unbearable to even try to speak to them at that point. They're trying to run a business together, and the other party is gloating like they've won everything possible, and this is going to be the greatest thing in the world for them. So it's their best day, but it doesn't have to be the worst day for you. However, it's going to be a rough day, and you'll build back from that. So the first thing we're going to do is look at how you were served. So if you were personally served and you accepted the documents, chances are you will not be challenging service. However, if you were served by finding the papers sticking out of a garbage can 2 neighbors' doors down, that might not be good service, and you may want to actually challenge the service. Now, one thing you should know about challenging service in court is oftentimes if you do that, you'll then be in the courthouse and the judge will just ask you, "Will you accept service while you're here?" And then that will begin your time period to respond. And that's the next step here, is we're going to look at the summons and see what it is asking you to do. Some summonses will say you've been served and you have 21 days, 30 days, 45 days, 60 days, whatever the time period is. It gives you a time period to respond and tells you how to respond. Other times you'll be served with papers that say you need to show up in court at such and such a time on such and such a date before such and such a judge. Other times it'll be just a Zoom hearing where the notice will say go to the Zoom link on this date, put in this code, and it will be a virtual court appearance. So whatever the summons asks you to do, that's the first thing you want to note is what is that next step. Whatever it is, make sure you understand that next step. The next thing you can do is read through the contents of the document. And again, like when you were first served, this is not going to be a pleasant experience. Chances are you're going to read through the allegations and become upset. Maybe there's things in there that didn't happen. You're convinced the other party is lying. Nobody's ever happy to see the allegations against them in the lawsuit, but you still need to make sure you read through them, because you never know what's in there. And if there's glaringly obvious mistakes, you're going to want to make sure you're filing your answer and pointing them out. And when we look at filing our answer, I want to talk briefly about if you choose to do nothing. Let's say you say, "I'm not even going to deal with it. I'm just going to ignore the paperwork." These can cause significant problems to take that particular position. One option the other party will have is what we call a default judgment, meaning you never answer. The court proceeding goes on without you. They enter a final judgment on default, and they can actually begin to collect money from you. That judgment can be taken to your bank, they can put a levy on your accounts, they can go after other assets. So I never counsel my clients to allow a default judgment to be taken against them. Even when there's problems with service, even when there's problems with the documents, a default judgment is not something you want to take a chance with, because there's only limited circumstances where you can undo that default judgment. And if you don't fall into one of them, you can be stuck with a judgment against you that you had the opportunity to fight, but you just chose never to do it. The other possible option is they can issue a warrant for you, meaning the judge can say, I want John Smith in front of me on March 1st at 9 a.m., and they can give it to the police and have the police come pick you up and take you to the courthouse on that date. What often will happen instead of a warrant, though, is that if you don't appear on the first date, the court will adjourn the date to a date in the future and have a notice sent to you. And again, when you ignore these notices, you're doing it at your own risk, the main risk being a default judgment that you may not be able to undo down the road. Now, as we go through all this, hopefully you understand the most important step I would tell you to take would be to speak to an attorney. So oftentimes my clients come to me very nervous because they've received this paper, they're not sure what it is, it says summons, it says complaint, it has all this legal jargon in there that they're not sure what it means. And then we sit down and we go through it, we all take a breath together and we say, wait a second, it's not that bad. We're going to put in our answer. And your answer doesn't necessarily have to be some big long narrative, it's going to be simple things like admit, deny, or I don't know. There's legal terms for how we do it. There's a form sentence that we use, but the fact is your answer is something that needs to be filed so we can protect your rights against the default judgment, and it also makes you feel better. So from that first date where you're feeling terrible, now we're slowly building back up. You're putting in your answer. Maybe you're going to do a counterclaim because you actually want to countersue the other party. And then guess what? When they get the counterclaim, now they're having a bad day. So they've been gloating for a couple of weeks, life is great, and then they get your response to their lawsuit, and their life's not so great either. They say, wait a second, I'm on the hook for legal fees maybe, I'm being countersued for frivolous litigation. There can be a lot of options in that answer that can really turn the tide in how people feel, and then from there your lawsuit will progress. But the important step in all this is, even if you're not going to hire one, speak to an attorney, go through your summons and complaint, your summons and petition, whatever you were served with. Make sure you speak to a professional so you understand what you are facing, because you do not want a default judgment. If you have more questions, you want to talk further about this, you can go to my website, andrewmayers.com. There's a red legal strategy session button on the front page. If you click that, you'll be taken to my personal calendar. We'll set up a 15 or 20-minute phone call where we can go through your questions. If you've been served with a document, we can review it and give you some next steps to take. If you like this video, you can hit the like or thumbs up button below. You can go over to YouTube and subscribe, or go to Ayerslaw TV. But if you're served with paperwork, the one thing you don't want to do is stick your head in the sand. Make sure you understand what those papers say and what you need to do next.